the international treaties ceded to by Uganda relating to copyright, to provide for copyright and neighboring rights protection in the use and exploitation through internet and other technologies or technological means, to provide for the management and exploitation of orphan works, to provide for the regulation of exploitation contracts, and to streamline the registration of collecting societies with the registrar. The Copyright and Neighboring Rights Amendment Bill 2025 was read for the first time in Parliament on the 13th of May 2025 by the Honourable Minister of Justice and Constitutional Affairs and referred to this committee in accordance with Rule 135 of the Rules of Procedure of Parliament 2025. And on the 7th of August 2025, the Honourable Attorney General formally introduced the bill to the committee for consideration. Honourable Chair and members, we received an invitation from this committee to provide for further clarification on issues raised by a number of stakeholders. We have accordingly prepared a comprehensive response that is here to attached. Honourable Chair and members, allow me to invite or request the Registrar General of Uganda Registration Services Bureau, Ms. Mase Keinobwisho, to do the presentation. Thank you.
Thank you very much, Honourable Chair and Honourable members. Thank you, Honourable Attorney General, for that remark. We are providing responses to the issues that were raised by stakeholders jointly, and just for the record, that the Attorney General's Chambers has all the experts on all the laws because they draft them and interpret them. And so the presentation that the experts are on in URSB is not correct. It also extends to the Attorney General's Chambers. Yes, there are issues. I will go through these issues clause by clause. On clause 4, page 1, Honourable Chair, it relates to the amendment of Section 12 of the Principal Act to delete subsections 6 and 7. The concerns of the stakeholders were that the period of protection for copyright in most countries, that is 73 countries, is 70 years, and so we should move this protection period from 50 to 70 years. We beg to submit that Uganda should maintain the 50-year period of protection of copyright as the minimum, because it's the minimum provided for by the Berne Convention of 1886. And also to take note, Honourable Chair and members, that the intellectual property system is meant to balance the rights of the holders and also the interests of the public. And the general principle always applied is especially in countries that are developing, like low development countries, least developing countries like Uganda, is to apply the minimum, and 50 years is sufficient to enable the works to enter into the public domain and exploitation. So our proposal is that in accordance with the international treaties such as TRIPS, each country is allowed to apply the minimum levels of protection, which is the standard, and following our development needs and our levels of development, it is sufficient that Uganda maintains 50 years as the basic minimum period of protection. On the clause 5 and 10, regarding the amendment of section 13 and 34 of the Principal Act to, among others, impose an obligation to have all contracts of assignment, license, or transfer to be in writing and registered with the registrar within 60 days of execution, and the failure to register renders the contract voidable. The stakeholders propose that this requirement for mandatory registration should be removed, and registration should be voluntary, and incentives must be provided to encourage registration, as well as contracts of assignment or license should not be voidable. The other issue of concern was the courts and the registrar should be empowered to reject to register or enforce contracts that contain unfair and unconscionable terms. The stakeholders' reasoning is that the provision is impracticable, and especially where rights are contracted to foreign entity which uses online and standard form virtual contracts, and in such a matter the provision will affect the contracting and assignment of rights, thereby shutting Uganda off the international investors and online commercialization of the creative industry, creative works. The bill also, according to the stakeholders, contravenes the provisions of Article 2 of the Berne Convention and Article 20 of the World Intellectual Property Performances and Phonograms Treaty of 1996, which the bill seeks to domesticate, which prohibit imposing of formalities on both enjoyment and enforcement of the works. Our response, Honorable Chair and members, is that we maintain the clauses 5 and 10 of the bill as proposed because of the following reasons. Whereas we appreciate that there are no formalities to the enjoyment of the works and enforcement as per the Berne Convention of 1886, there are so many emerging issues that have come on board. The proposal is intended to protect the vulnerable creators who sign away their rights in unfair and opaque contracts. And this has been a complaint from the artists that they signed contracts without knowledge and signed their rights in perpetuity. The other reason is to ensure that there's transparency in the industry. Failure to register the contracts creates uncertainty among the sector players, and this limits the commercialization of copyright, like the use of copyright as a collateral is one of the examples. Registration also would create a comprehensive database of rights determination, which protects all parties involved in the ecosystem and increase the viability of copywriters for commercialization. The other reasoning is that the contracts involving the foreign parties are usually governed by other laws. There's already a legislative system, the Copyright Act, that regulates and guides the contracts generally, and in most instances, if not at all, will not apply. The parties will also be at liberty to choose the law if the assignment involves the foreigners, because there's freedom of contracting in Uganda. It does not contravene the Berne Convention as stated by the stakeholders. The Berne Convention of 1886 is, and the Article 20 that has been referred to of the WIPO for Performances and Phonograms Treaty only provide for protection and enjoyment of copyright as an automatic right, and this principle must be maintained. Yes, to get copyright, it must be expressed, it must be put in tangible form, and there must be some level of creativity, and so it is automatically protected. The issues relating to registration are to enhance the evidential value of every transaction that is involved in the copyright ecosystem. So there's no international treaty that regulates copyright contracts at all, and the bill intends to provide for just regulation of contracts relating to copyright. The other issue is that the courts are already empowered to adjudicate over contracts and determine the unfairness and reasonableness, and so there's no need to worry. The on page 3, the other concern by the members was that the bill also contravenes Section 3.2 of the Principal Act, which provides that the protection of works of the author shall not be subject to any formality. The registration is cumbersome and costly given the financial position of many creatives. The non-registration will lead to loss of property, yet copyright is inherent, an inherent right for works invented, and that the creative, it will create predatory behavior, since people are likely to register works that are not theirs because they acted faster than the creatives. The response is that the registrar should not be empowered to reject the registration of copyright due to the party autonomy principle under the contract law, because it's already taken care of by the contract laws. Then the issue of registration fees is addressed by the minister through the regulations, and these fees are never a deterrent, and in any case they are to enhance the protection system, because we're looking at a balancing of rights. Since copyright is a private right, the members should appreciate, the stakeholders should appreciate that we have to put protection mechanisms around their rights. The non-registration of contracts will not affect the ownership of copyright, because registration is optional, and if it is not registered, it will not affect the ownership at all. So there's no need to worry, as expressed by the stakeholders. The other issue is that the registration is not for copyright works in this case, but for the transactions, because these are transactional matters, Mr. Chair and honorable members, and any transactional agreements which affect the benefits and not the works themselves must be registered for transparency, for accountability, for tracking, and for sustainability, among others. Regarding Clause 6, which provides for insertion of Section 13A, 13B in the Principal Act to provide the reversion of rights after 20 years back to the author, the stakeholders' concerns are that they are objecting to the proposal on the following grounds: that the provision will frustrate the freedom of contract and unlawfully deprive the copyright owners of full utilization of their rights. And the other concern from the stakeholders is that the provision risks fragmenting the rights owned by individual rights owners in the copyright works, and deny each party the right on their own and to individually license and fully utilize the rights. Honorable Chair and members, our proposal is that the proposed amendment should be maintained, because it is intended to protect both the authors and the creatives of copyright works from the consequences of their inadvertent transfer of rights. This provision was introduced in the bill upon request from the creatives themselves and the complaints that they have signed contracts in perpetuity that are not defined and do not indicate any terms, and it is very difficult to follow up on the matters that relate to the assignments and transfers, among others. And so it is to enhance their protection in respect to the contracts deemed to be unfair at the time of execution. And we beg that this should be maintained, because it's for their own benefit. And the same stakeholders who have been complaining about the lack of clarity under the law in terms of the reversion of rights. And so 20 years is ideal. In some countries, they provide 25 to 30 years as well. And also this is will help the heirs to these creatives in terms of the commercial, moral, and economic benefits of their works. The other concern is listed on page 4, and these have been responded to by the fact that we submit that the clause should be maintained for the reasons that have been given. All these reasons that have been given are to balance the rights between the owners of rights, but also the creative industry, and it is in their own benefit that we maintain this provision. And honorable members, actually the proposals and all these clauses are for the benefit of the creatives to the biggest extent. On page 5, honorable chair and members, it refers to clause 8, the insertion of section 14A and 14B to provide for the orphan works and the restrictions on reprographic copying. The stakeholders raised the following concerns: that in the proposed subsection 14 B2, the provision restricts the exercise of the minister's discretion to only persons who cannot be identified, yet the definition of orphan works includes persons who cannot be found as well as those who cannot be identified. The other concern is that whereas the provision grants all economic rights to a person licensed to exploit orphan works by the minister, the provision does not contain the requirement on the license to compensate the author of orphan works and collecting society, if any, and for exploitation of the orphan works in the situation where the author is identified and found. The other concern by the stakeholder is that the provision does not prescribe the period for the license issued by the minister to exploit the orphan works, and that the provision does not recognize the role of collective management societies in the licensing of orphan works which they manage. The stakeholders also propose the following: if the provision is to remain part of the bill, their proposal is to the effect that they require an applicant seeking a license to exploit orphan works to obtain a letter of no objection from the relevant collective management organization, or they require the collective management organization where orphan works are managed by the relevant collective management organization to receive applications and issue licenses for exploitation of orphan works instead of the minister. They also require the minister to consult the collective management organizations in issuing regulations for accessing orphan works. And lastly, they require that the minister share with the collective management organizations the monies arising from the licensing of orphan works by the minister. The response, Honorable Chair and Honorable Member, is that we agree with the committee that recommends to amend clause 14B 2 to include persons who cannot be identified as follows: that the minister shall not license a person to exploit an orphan work unless the applicant has demonstrated to the minister that the author of the work cannot be found or identified. We also propose, Honorable Chair and members, that the other provisions of clause 8 be maintained as provided in the bill because of the following reason. One, a licensee of an orphan work has exploitation rights during the subsistence of the license and cannot be required to compensate the author for the period he or she is holding the license, and the copyright reverts to the author before the expiration of the license. Secondly, the clause 14B 5 empowers the minister to make regulations on such matters like the period of the license, and this will be done in the regulations. We cannot provide this in the main act. The third issue is that collecting societies, which are collecting management organizations, cannot be expected to have rights over orphan works because the author and the owner cannot be found or identified, and so cannot be a member of the collecting society. A collecting society represents the owners of these rights, and so if a work cannot identify the owner, it means that they don't belong to the scope of the collecting society, and so it does not apply. Mr. Chair, on page 6, which refers is that we agree with the committee that recommends to amend clause 14B 2 to include persons who cannot be identified as follows: that the minister shall not license a person to exploit an orphan work unless the applicant has demonstrated to the minister that the author of the work cannot be found or identified. We also propose, Honorable Chair and members, that the other provisions of Clause 8 be maintained as provided in the bill because of the following reason. One, a licensee of an orphan work has exploitation rights during the subsistence of the license and cannot be required to compensate the author for the period he or she is holding the license, and the copyright reverts to the author before the expiration of the license. Secondly, the Clause 14b(5) empowers the minister to make regulations on such matters like the period of the license, and this will be done in the regulations. We cannot provide this in the main act. The third issue is that collecting societies, which are collecting management organizations, cannot be expected to have rights over orphan works because the author and the owner cannot be found or identified, and so cannot be a member of the collecting society. A collecting society represents the owners of these rights, and so if a work cannot identify the owner, it means that they don't belong to the scope of the collecting society, and so it does not apply